Thank you all. Please sit down. Good morning, everyone. This is the first hearing of the independent public inquiry into the murder of solicitor Mr. Patrick Finucane, who was killed by loyalist paramilitaries on the 12th of February 1989 at his home in North Belfast. I'm Gary Hickinbottom, the chair of the inquiry, and it's my great privilege to welcome you all here today. Before I begin, may I acknowledge, on behalf of the inquiry, the events of the past 2 days. Our thoughts are, of course, with the gentleman attacked in John Finucane's constituency on Monday, and with all those affected by last night's unrest. Turning to this morning's hearing. This is an administrative point, but one of some importance. I'd like to draw your attention to the restriction order on delayed broadcast of hearings, copies of which are displayed throughout the hearing centre and published on the inquiry website. I remind everyone that anything you hear during the course of inquiry proceedings must be kept confidential and must not be disclosed or published in any form unless and until it has been broadcast on the time-delayed YouTube platform or a transcript has been published on the inquiry's website. Any information heard today which is redacted from the YouTube video or the published transcript must not be repeated or disclosed to anyone else. There are a number of points I would like to address in these brief opening remarks. First, I'd like to make a few observations on the murder itself and on its impact, particularly on Patrick Finucane's family. Second, I'll move on to say a few things about the long history of the efforts to uncover the truth in relation to this murder, culminating in this inquiry. I will explain my obligations with reference to the legislative framework and our terms of reference, and also distinguish how this inquisitorial process differs from other types of legal proceedings and from the other investigations which have already taken place into Mr. Finucane's murder. Third, I will set out briefly what I expect from those who engage with the inquiry in a formal capacity, whether as co-participants or as providers of information, including witnesses, providing evidence, as well as members of the public who might have important contributions to make. Fourth, it's important that I say a word or two about how I intend to conduct hearings, balancing openness against some of the sensitivities we will encounter, for example, in relation to national security. Fifth, I'll provide some detail on how this inquiry will embark on a trauma-informed approach to our work, including the support that will be available to those affected by any of the matters arising from the topics we will explore. Finally, I'd like to use this opportunity formally to introduce the wider inquiry team, including the two independent assessors here, counsel to the inquiry, the secretariat, and the legal team led by the solicitor to the inquiry. So first, the murder and its impact. You will all know that Patrick Finucane's brutal murder took place at his home in front of his wife Geraldine, who was also injured in the attack, and in front of their 3 children, Michael, Catherine, and John, who were respectively 17, 12, and 8 years old at the time. This horrific murder remains one of the most high-profile and controversial of Northern Ireland's troubled past. It is, of course, one of thousands of incidents involving loss of life or serious injury during the turbulent history of Northern Ireland. As we embark on our work, let us just take a moment to pause and remember all of those who lost loved ones and friends, and those who suffered pain or injury during that period, and the many who still carry the scars, physical and psychological, today. I am honoured to have been asked by the Secretary of State for Northern Ireland, Hilary Benn MP, to take responsibility for leading this inquiry. In conducting this inquisitorial process, I hope to establish the truth surrounding Patrick Finucane's murder. To that end, I'm determined to fulfil my duties diligently, fairly, and as transparently as I can. In my statement following the publication of the terms of reference in March this year, I outline my proposed approach to the work of the inquiry and will add some further comments to those today. In that statement, I welcomed having had the opportunity to meet Mrs. Finucane and her family. The family has campaigned tirelessly for the truth, justice and accountability over very many years. They have displayed great resilience and great dignity throughout that time. That sense of purpose, that sustained determination was reflected in our conversation then. I'm pleased to see them here today to witness this further step towards the culmination of their efforts. As you'll have seen from the guidance we have published, generally those under the age of 18 will not be allowed to attend proceedings of the inquiry in this hearing room. However, having considered the central role of the family in bringing about this inquiry, their wish to attend this preliminary hearing with other family members, the closeness of the Finucane family, and the inquiry's safeguarding obligations and trauma-informed approach, to which I'll return shortly, I have made a specific exemption and allowed some of the younger members of the Finucane family to attend today, and indeed they are very welcome. I now turn to the circumstances in which this inquiry has been called. I'm very sensitive to the fact that countless people in Northern Ireland have been profoundly affected by horrors inflicted throughout the period known as the Troubles. I am all too aware that many are still searching for answers and ultimately justice in respect of their loved ones. In relation to the murder of Patrick Finucane, there have been several earlier investigations, details of which are set out in the inquiry's terms of reference. Notably, in 2004, Justice Peter Corey published the Corey Collusion Inquiry Report. Justice Corey, a retired judge of the Supreme Court of Canada, was asked by the United Kingdom government to investigate allegations of collusion by members of the security forces in the context of the deaths of Patrick Finucane, Robert Hamill, Rosemary Nelson and Billy Wright, and to report with recommendations for any further action. He found that in each of the 4 cases, documentary evidence indicated matters of concern which would warrant further and more detailed inquiry. Public inquiries have been carried out in relation to Robert Hamill, Rosemary Nelson and Billy Wright. As I indicated a moment ago, what occurred on that February evening 37 years ago in the Finucane family home and how it occurred has been the subject of several previous investigations and reviews, during which much evidence has been considered. Those investigations raised important and concerning questions about Patrick Finucane's murder, including in relation to the role of the state. However, they fell short in one important respect. In 2019, the United Kingdom Supreme Court concluded that there had not been an inquiry into the death of Patrick Finucane, which was compliant with Article 2 of the European Convention on Human Rights, as the circumstances of his death required. As such, Patrick Finucane's death remains the only individual outstanding from Justice Corey's review for whom a public inquiry has not been conducted. Article 2, which enshrines the right to life, is a key provision within the European Convention. It imposes both negative and positive obligations on the state. It places various duties on the state to protect people's lives, but it also imposes an obligation on the state to investigate where there are arguable breaches of those duties. This statutory public inquiry has therefore been established under the Inquiries Act 2005 to complete an Article 2 compliant investigation into the murder of Patrick Finucane. In pursuit of the truth, I will build on the important work of those earlier investigations and reviews to which I've referred and will address the shortfalls in them. The 2005 Act defines the powers that I have. It sets out what I can do and what I cannot do. I can require organisations and individuals to provide me with evidence and documents. I can compel witnesses to attend and give evidence on oath. Penalties may attach to those who fail to comply. None of the earlier investigations had those powers. I can decide on the processes and procedures that the inquiry will adopt, subject to the terms of the statute and the requirements of the common law. The Act requires me to act fairly and to avoid unnecessary cost. It also places some specific limits on me. I may only investigate matters that are within the inquiry's terms of reference, and perhaps most importantly, the Act prohibits me from ruling on or determining any person's civil or criminal liability. That is a job for the civil and criminal courts. The inquiry's job is to make findings of fact and recommendations. Using the powers I have, including the powers to compel evidence, I expect this inquiry to obtain material that was not available to those who oversaw earlier investigations. Indeed, it is important, and I will ensure that as part of this inquisitorial process, we will conduct our own investigations. We will consider all of the evidence we obtain, including that which was available to the earlier investigations and all the new evidence we are able to gather, and from that evidence I will draw my own conclusions and make my own recommendations. We will do all of that independently of all external influence. Independence is central to the work of this inquiry and to my role in it. Although the inquiry, of course, has been established by a government minister, it will act independently and impartially. His Majesty's Government is one of the several core participants, all of whom will have an opportunity to work with the inquiry and to make submissions to me. I will endeavour to obtain and consider the views of core participants insofar as I am able to do so. I will listen to all of those voices, but I will then make my own decisions without fear or favour. The conclusions I reach will be my own, informed by the evidence and the submissions I receive, and nothing else. I would like now to discuss briefly the specific questions this inquiry has been tasked with addressing, which cut to the heart of the state and its obligations to protect people. The inquiry's terms of reference specify that, and I quote, "The investigation will seek to determine the circumstances of Patrick Finucane's murder, establish the identity of all those involved in his murder and the nature of their involvement, establish whether the evidence indicates that the murder could have been prevented, and investigate acts or omissions that are relevant to the murder. In doing so, it will be incumbent upon me to," and again I quote from the terms of reference, "ensure that there is no unnecessary duplication of the investigative work that has already been undertaken." The allegations at the centre of this inquiry, particularly those concerning state collusion, are of course very serious. This inquiry will take great care to ensure demonstrable fairness in how it approaches this important work. Inquiries are correctly described as being inquisitorial, in contrast to litigation in the civil and criminal courts, which is adversarial. In a trial, the two sides present their opposing cases, cross-examine one another's witnesses, and make their arguments to the judge or jury, who then decides who has won and who has lost. An inquiry is very different. There are no indictments or pleadings. There are no opposing sides, no cases to put or be proved. It is the chair of the inquiry who determines the witnesses to be called and the evidence to be considered, informed and assisted by the views of the core participants, with the aim of making findings as to what happened in the past and recommendations as to what should happen in the future. It is or should be a collective endeavour. With that in mind, I turn to the expectations I have of those engaging with the inquiry. While acknowledging how vital it is that we maintain our independence as an inquiry, those who engage with us have an important role in assisting delivering our terms of reference. Given the time it has taken to establish this inquiry, I am keen to move forward as quickly and effectively as possible. I am empowered to appoint core participants at any time, provided they consent. A core participant is a person, organisation or other entity that has been designated as a core participant in the inquiry by me under Rule 5 of the Inquiry Rules 2006. When considering who should be a core participant, there are a range of factors for me to consider, including whether the prospective designee played or may have played a direct and significant role in relation to the subject matter of the inquiry, or has a significant interest in the inquiry's work, or may be subject to explicit or significant criticism arising in or from the inquiry's work. This status is reflected by the fact that they are typically afforded specific rights and given specific responsibilities in relation to the participation in the inquiry, though there are other effective mechanisms available for people to engage with the inquiry, for example as witnesses or providers of documents or other information. Core participants remain as such until the end of the inquiry unless I specify a date in writing. I have already appointed several core participants and may appoint others in time. I will keep the question of core participant designation under careful review as the work of the inquiry progresses. The list of core participants available on the inquiry website will be updated to reflect any changes. I expect core participants to work with us in a spirit of cooperation and collegiality. Just as my team and I will proceed with courtesy and mutual respect, I expect reasonableness and courtesy in return. I will not allow unreasonable conduct to disrupt or otherwise inhibit the inquiry from carrying out its functions. I expect that core participants and those from whom I request evidence and material to respond promptly, comprehensively and in good faith, and to help identify and provide information and evidence relevant to our work. I expect public bodies and their representatives to carry out disclosure exercises with full candour as reflected in the Nolan Principles. This is coupled with the expectation that all who contribute to the inquiry will cooperate fully and ensure maximum transparency in the spirit of the Inquiries Act 2005. Before this hearing, I have met with the legal representatives of each of the core participants who have assured me that the core participants will fully cooperate and give the inquiry their assistance. In addition to evidence which the inquiry will actively request from core participants, organisations and certain other witnesses, I would very much welcome contributions from anyone else who believes they're in possession of information or material which they consider would be of interest to our work. Details on how such contributions can be submitted will be published on the inquiry website in due course. For now, I urge anyone who thinks they have relevant evidence to retain and preserve it with a view to providing it to the inquiry in due course. In passing, I should draw attention to the fact that the Inquiries Act 2005 makes it an offence intentionally to alter, destroy, suppress or conceal documents known or believed to be relevant to our investigation. Many of you will understandably wish to know how long the inquiry will take. However, you'll understand that even with our best efforts, these processes will take some time. I will ask counsel to the inquiry, Mr. Hill, to deal with this in more detail in his introductory remarks shortly. But it is important that whilst moving as quickly as we are reasonably able, we are thorough and methodical, not least to ensure that the concerns identified by the Supreme Court in 2019 are addressed. We owe it to the public whom we serve, and of course the Finucane family and others affected directly by Patrick Finucane's murder, to find answers if we can. I will therefore resist pressure now to commit to a finishing date, but I can promise that my team and I will take forward our work as quickly as we can. I also commit to keeping the public, as well as the core participants, informed of our progress via our website and social media throughout the course of the inquiry. As to the conduct of hearings and handling of evidence, An initial assessment of the types of issues which have been covered by previous reviews and investigations suggests that we will encounter sensitive material, for example, which engages national security or which might give rise to the risk of life of individuals were it to be made public. This will require careful and sensitive handling, and while I will hold all hearings in as open a manner as possible, circumstances and the law might at times necessitate that our work is done in private. But where I decide to withhold certain material from publication, this will only be done where there is a legal requirement to do so. I may also be required to hold some hearings in closed session where the public and others engaged in the inquiry may not be able to attend. As I stipulated in March, I will only resort to closed hearings where they are strictly necessary, for example, for reasons linked with the Article 2 right to life or national security. And should there be a need for closed hearings, I will endeavour to deliver a process which will allow core participants to be in possession of as many of the facts as possible. My team will also provide as much information as we can to other material providers and witnesses where they may need to engage with a closed process. I also repeat my promise from March that I'll ensure that as much information as possible about any closed hearings, including the content of such hearings, is made public. When evidence is heard in open proceedings, the expectation that they will be here at Bradford Court. As you will see, this hearing room is perhaps smaller than the level of interest in this inquiry might at times demand. My team will make every reasonable effort to maximise the available space and to balance the different needs of core participants, the public and members of the media. To that end, hearings will be streamed, subject to a short delay, in a public viewing annex in this building, as well as via the inquiry's YouTube channel. This will doubtless be an ongoing process, and we would be grateful for your cooperation and indeed for your feedback as hearings progress. My aim and that of my team is to make this a safe, respectful, welcoming and neutral space in which to carry out our work. We have published a code of conduct to which I expect all attendees to adhere. I ask everyone engaged with the inquiry to familiarise themselves with its contents. I do not expect anyone deliberately to disrupt our work, but as I've already indicated, disruption to proceedings or any attempts to intimidate or cause distress to witnesses, inquiry staff or other attendees will not be allowed, and I reserve the right to ask anyone to leave should such a situation arise. On that point, I now turn to how this inquiry will take a trauma-informed approach to our work. As I mentioned at the beginning of my statement, at the heart of this inquiry is the brutal murder of Patrick Finucane, which has had an enduring impact on his bereaved family and many others. That will require consideration of evidence that will be capable of triggering traumatic memories. It's also important that we don't lose sight of the potential human impact as we move forward with our work. I'm alert to the fact that such memories may not be easy to deal with. Indeed, there is no doubt that much of what will be explored during the inquiry has the potential to reopen old wounds for many people involved with or affected by horrific events which occurred across this part of the world during recent decades. Any witness may be so affected, and my team and I are sensitive to that and will remain so until the conclusion of our work. With that in mind, we intend to apply the principles and practice of a trauma-informed approach in our process and engagement mechanisms. Our primary goal in this is to ensure that the inquiry avoids re-traumatisation of those directly or indirectly affected by the murder under investigation or indeed similar other events. Secondary goals include ensuring that vulnerable witnesses receive appropriate adjustments to secure best possible evidence and avoid re-traumatisation where applicable, and potentially vicarious trauma for inquiry staff, all legal teams, members of the public and the media. To deliver this, the inquiry team has established a series of actions and protocols that will apply throughout the course of the inquiry. Our approach will be focused on four main themes, namely safety, trustworthiness, choice and collaboration. We will take practical steps, including the establishment of liaison points of contact to engage directly with the family and other core participants, with witnesses and, where appropriate, with their legal representatives. We will ensure appropriate and timely familiarisation of the hearing venue and related policies to all concerned. We will ensure that inquiry timetabling takes account of the enhanced needs for certain witnesses when giving evidence. For instance, I may allocate additional time for reflection, support and private time when evidence is challenging, and I may also direct shorter hearing days or sessions for vulnerable witnesses. We will also put in place measures to provide or signpost support services for those affected by the evidence. I would like to express particular thanks to the Wave Trauma Centre, a cross-community victims group which is supporting us in these efforts. I will, of course, enjoy the vital support of a number of people throughout this inquiry to deliver our terms of reference. They include my two independent expert assessors, Baroness Nuala O'Lone and Miss Francesca Del Messe, who sit beside me this morning. Baroness O'Lone may be a familiar face, as she has dedicated much of her life to public service in Northern Ireland, including as First Police Ombudsman and more recently as a member of both the International Steering Group for Operation Canova and the group of experts and stakeholders for the McCulloch Review into PSNI surveillance of journalists, lawyers and other groups. Among other things, she was also Ireland's Special Envoy for Conflict Resolution. Ms Del Messe's work has taken her across the world to countries with histories of conflict. She is an international criminal and human rights lawyer specialising in security sector reform in conflict and fragile states and countries experiencing political transition. Among other notable appointments, she serves as a judicial member of the Investigatory Powers Tribunal, the United Kingdom's judicial body that oversees MI5, MI6, GCHQ, police forces and other state entities that hold intrusive powers. She is also on the United Nations Security Council's list of experts and is a member of various UN and UK government expert panels. Each brings a great breadth and depth of experience to this inquiry, and will help optimise the independence of its work. Details of how the assessors will interact with the inquiry are set out in a protocol which was published on the inquiry website in March of this year. Much work will be done by Mr. Matthew Hill, to whom I've referred already. He has kindly accepted the pivotal role of counsel to the inquiry, where he will lead a small team of barristers comprising Alex Jamieson, Saoirse Townsend, Max Mills and Megan Miller. Each of Mr. Hill's team brings valuable experience from across a range of inquiries and inquests, including previous roles as counsel to an inquiry and as representatives variously to victim groups and families, to state bodies and to individual witnesses. In addition, I enjoy the support of a small but dedicated secretariat and legal team headed by Alison Bennett and Stephen Brown, respectively. Both teams bring a broad and diverse range of skills, knowledge and experience to our work. Based on our collaboration to date, I've no doubt that this experience and expertise will prove invaluable as we progress with our work. I will shortly invite Mr. Hill to provide an update on the work of the inquiry and give an overview of planned next steps for the weeks and months ahead. On completion of Mr. Hill's submissions, I will invite each of the core participant representatives to introduce themselves, to identify those for whom they appear, and to present short opening remarks should they wish to do so. Representatives have been informed that Mr. Danny Friedman, King's Counsel, on behalf of the Finucane family, will frame his opening remarks around a note which I recognise contains sections that may not be agreed by all participants. On this occasion, I've acceded to the request on the basis that there will be an opportunity for each core participant to make a full opening statement at a future hearing and to respond fully in writing to the note if they wish to do so. For today, I kindly ask that contributions by core participants are limited to no more than 15 minutes. In concluding, may I thank you all for your attendance, your attention and your interest in this inquiry. I look forward to pressing on expeditiously with our work. I will now pass over to Mr. Hill. Thank you.
Thank you, sir. I speak on behalf of the Counsel to the Inquiry team, which, as you have said, comprises Alex Jamieson, Saoirse Townsend, Megan Miller, Max Mills and myself. It is likely that others may be instructed over the course of the inquiry. The team has acted in many inquiries and inquests, including those into Bloody Sunday, the Hillsborough Stadium disaster, infected blood, the Manchester Arena bombing, the Post Office Horizon IT scandal, the McCulloch Review, and the ongoing Afghanistan, Southport and Nottingham inquiries. In those inquiries and inquests, we have represented bereaved families and victims. We've represented government departments, politicians, civil servants, members of the police and armed forces, and, in particular, we have acted as counsel to the inquiry. We also have extensive experience within the team of dealing with matters relating to national security, including as a special advocate acting on behalf of individuals excluded from such proceedings. I would like to address you on two matters today. First, the role of counsel to the inquiry and the approach that we will take to our work. And second, some preliminary thoughts on how the inquiry should proceed in the coming months. The role of counsel to the inquiry is to assist the chair and the inquiry in fulfilling the terms of reference thoroughly, fairly and efficiently. It is our job to help gather and deduce the evidence that you, sir, will need to consider when coming to the conclusions required of you. In doing so, we will help ensure that the processes adopted are legally sound, fair and proportionate. In these and in all matters, we act as independent barristers. We are instructed by the solicitor to the inquiry, Mr. Brown, as your counsel, but we undertake that role from an independent perspective. We have no case to advance and no interest to pursue other than the public interest in ensuring that the inquiry fulfills its terms of reference and is conducted fearlessly, rigorously and efficiently. We are instructed to advise and to assist, but not to decide on points of contention. Those decisions are for you, sir, as chair. That is so both for case management decisions and for the conclusions that you will reach in your report. It may help to set out briefly some of the functions that we will undertake to further explain these points of principle. The most obvious role of counsel to the inquiry is to question the witnesses that you call to give evidence. When we do so, we seek to achieve two things. First, to allow that witness the opportunity to give relevant evidence to the inquiry. Second, to test that evidence by reference to other material before the inquiry or to the inherent plausibility or logic of the account that is being presented. We do not do this to put a case, as would be done in adversarial litigation. As I have said, counsel to the inquiry have no case to put, and as you have said, these are inquisitorial proceedings. We put questions to allow the chair and the public to hear the evidence of the witness and come to their own conclusions on it. Witnesses must be allowed the appropriate space and environment to give their relevant evidence. Part of our role is to ensure that happens. This does not mean we agree with that evidence, still less that it will be accepted by you as chair. But the fundamental purpose of calling a witness is to hear what they have to say, even where those listening may object in the strongest terms to the accuracy of the account or the ethos that lies behind it. Those with relevant evidence to give in rebuttal will have an opportunity to put that to you as chair. Our approach to questioning will be guided by the principles of independence and fairness, the latter extending not just to the witness before us, but also to those individuals affected by that witness's evidence. We will test the evidence robustly, but always with those principles in mind. As you have said, sir, the inquiry and its counsel will take a trauma-informed approach to all interactions with all witnesses. We recognise that witnesses may find requests to provide evidence destabilising and distressing. Support will be offered, both by the inquiry and in collaboration with the core participants assisting those giving evidence. Your team will always welcome conversations about how best to approach witnesses and how best to obtain their evidence, considering their individual circumstances. More generally, we welcome the knowledge, suggestions and questions of the core participants, which will inform the matters that we raise with witnesses. In due course, a process will be put in place to allow such liaison to take place efficiently. I will return a little later to the collegiate approach that we will adopt and encourage. The second role for counsel to the inquiry is making submissions to the chair on evidence, on procedural matters, and on legal questions that arise during the inquiry. Those submissions will, in general, be made publicly where the law allows. Our intention is to help the core participants and the public to understand the matters that the Chair will have to decide and the wider progress that the inquiry is making. Part of the purpose of our submissions is to help frame the debate and focus the collective efforts of all involved on the most important matters that require your attention. It is also our role to ensure that the full range of lawful options are before you when you make your decisions. However, counsel to the inquiry may have a view on what amounts to the best course of action. That will be based on an independent assessment of what the balance of evidence shows, or where the law points, or what is the most efficient, effective, and fair way to proceed. Such submissions will be made from an independent, neutral perspective, but that does not preclude advocating for a preferred outcome. To borrow a phrase, an open mind is not necessarily an empty one. On significant matters and points of contention, you will, no doubt, wish to hear submissions from core participants. These may be made in writing or orally, and, subject to legal requirements and your discretion, they may be given publicly at a hearing and published on the inquiry's website. It will be for you, as Chair, to make decisions on contentious issues, having heard all the relevant submissions. You may well choose to reject counsel to the inquiry's submissions and prefer those of a core participant, or to come to a different conclusion altogether. This highlights the distinction I made earlier between the Chair and counsel to the inquiry. We help to provide and present the information, but you are the one who decides. Other elements of the work of counsel to the inquiry are done behind the scenes. Indeed, this is where most of our initial work will be undertaken. It will include 1. Helping the solicitor to the inquiry to identify and obtain relevant evidence. 2. Assisting in drafting requests made to individuals and organisations for that evidence. 3. Analysing the material received by the inquiry to assess what is sufficiently relevant to be admitted into evidence. 4. Working and advising on the redaction of documents in line with the inquiry's protocols. 5. Drafting preparatory documents, such as chronologies, overviews, and agreed facts, which may be shared with core participants and admitted into evidence. 6. Advising on and drafting the inquiry's published protocols, including those already on the website that you have mentioned. 7. Helping to organise the oral hearings and the processes for receiving written evidence and written submissions. Finally, advising on the myriad legal issues that will arise during the inquiry. In general, where we make submissions to the Chair on contentious matters, those submissions will be made or repeated in public for reasons of transparency and to allow core participants to make submissions of their own. There are exceptions to this. Where you as Chair seek legal advice in respect of an actual or threatened judicial review, or on other matters that engage legal professional privilege, that advice will be given privately in the same way that a lawyer gives advice to a client. It will be privileged and does not fall to be disclosed. A further exception may come when the law requires that evidence is heard in closed proceedings. As you have said, it may prove necessary to hold closed hearings, given the nature of this inquiry. Counsel to the inquiry's independent role is of particular importance here. We will assist by assessing and evaluating closed material. We do so first to test its evidential worth, and second, to interrogate the claims to sensitivity for the purposes of ensuring that as much is made public as possible, and material is only considered privately where it is truly essential to do so in the public interest. It will be part of our role, working with the wider inquiry team, to discuss and liaise with those providing the material and those who assert that the information contained within it should not be publicly disclosed. We will approach this exercise in a cooperative, collegiate manner, but will challenge the claims to sensitivity to ensure they stand up to scrutiny. Where material is truly sensitive, we will seek to consider alternatives to the binary of either allowing material in open or restricting it to closed hearings. For example, we will always consider whether gists can be provided, or summaries made through open witness statements, or whether some parts of the evidence could be redacted. In this task, we will work collegiately with the material providers, but we will do so with questions and, where appropriate, with challenge. There is a strong public interest in as much information being made public as the law will allow, particularly given the history of the investigations into Patrick Finucane's murder. Our team has experience in this field, including prior work as counsel to the inquiry, as well as having acted for state bodies, families and victims, and as a special advocate, representing those who, for reasons of law, cannot be provided with the closed material. Our approach will be guided again by principles of independence, fairness, thoroughness, and efficiency. We will look to provide pragmatic solutions. However, where no such solutions are found, or where matters cannot be agreed, they will be brought before you as chair for your determination, subject to the oversight of the courts. Again, counsel to the inquiry assist and make submissions, but the ultimate decisions are for you as chair. The collegiate approach that I have mentioned in respect of closed materials extends to all other aspects of our work and to our approach to all core participants. Counsel to the inquiry do not claim a monopoly of wisdom, and we are acutely aware of the expertise available from the legal teams and clients of the core participants, and indeed of witnesses who are not core participants. We are open to working with all who are sincerely committed to assisting this inquiry. We are open to their perspectives, their knowledge, and their concerns. We recognise that two people may look at the same set of documents and reasonably come to different conclusions in good faith. That is a truth not always universally acknowledged in public inquiries, but it will inform our approach. We will do what we can to encourage and contribute to the collegiate atmosphere that you expect. It is our invariable experience that public inquiries work best when those involved work together. I turn now to a few initial observations about the structure of the inquiry and the work that it will undertake in the coming months. I emphasise that these are provisional and will be revisited once the inquiry is able to access more of the evidence that will form the bedrock of our work. The initial work of the Counsel to the Inquiry team has focused on an ongoing review of publicly available material. This includes the public reports of previous investigations and open source material such as books, articles, and media reports. We are also involved in the inquiry's efforts to understand the scope, location, and archiving of material that is not in the public domain. The inquiry has contacted various organisations that hold or may hold relevant material and has received initial statements from some of these. Once the material is identified and located, it will need to be reviewed, assessed, coded, and prepared for use by the inquiry, including, where legally permissible, prepared for disclosure. This work is time and labour intensive. It involves the wider inquiry team, which includes archivists and researchers, as well as lawyers. There are no shortcuts, and the challenges are increased by material being held on different sites, in different formats, and within systems that have changed over the years and will often not allow for materials to be easily searched or transferred. Individual documents may be held in duplicate or near duplicate form in different archives. These must be checked against one another. It is a painstaking process, but it is essential that it is done accurately and done well, as it is the foundation on which the forensic work of the inquiry will be built. The magnitude of this task should not be understated. It involves a product of more than 30 years of formal and informal investigations, where only the tip of the iceberg has been seen by the public. Sir Desmond de Silva, Queen's Counsel, stated that his team had located over 1 million pages of documents which formed the basis of his review. More than a decade has passed since then, during which time still more evidence has accrued. Working through this material will take considerable time, but that investment will be repaid. It will allow for greater efficiency, greater focus, and greater forensic rigour during the inquiry hearings and in your report. The initial work will, however, take place largely in private and without fanfare. The inquiry does not control all elements of this timetable. Its progress will be dictated by external factors. These include the extent of cooperation that it receives from organisations holding the material in questions, be they government departments and agencies, the police or armed forces, or other bodies or individuals. The assistance organisations can give will be dependent on the degree of resourcing and prioritisation that they allocate to the inquiry. We recognise that many of these organisations, inevitably and properly, have many other vitally important functions to fulfil with finite resources. All involved will need to approach matters with a healthy degree of realism. The pace of the inquiry will also be dictated by the speed at which it can finalise the establishment and implementation of suitable systems and physical facilities. The inquiry team began the task of putting these in place as soon as the inquiry was established. That work remains ongoing. However, we are reliant on the continued assistance of external organisations to procure appropriate infrastructure. There is limited efficacy in reviewing materials in situ when the inquiry is unable to log, code, and process the documents so that it can use them in its submissions, presentations, and hearings. Working this way can cause duplication, waste of resource, and unnecessary cost. Until the inquiry can receive and work on documents on its own suitable systems, progress will be slowed, no matter how hard the inquiry team works. It follows that there will be a period during which most of the inquiry's work will take place out of a public site. This is inevitable, and for the reasons I have given, it is important that this work is done thoroughly, accurately, and systematically. Other inquiries have cut short this process, electing to proceed to hearings at an earlier stage. Many have come to regret that decision. We will approach the task diligently and determinedly, seeking to make progress as efficiently as possible while establishing solid foundations for the inquiry's work. This will require patience from those awaiting the full outcome of that process. There are, however, two areas in which we invite you as chair to hold public hearings while this process is taking place. First, we consider that it would be helpful to spend some time setting out at a hearing what can be gleaned from the publicly available evidence in this case. We will propose to do this through counsel to the inquiry producing a presentation on what open source material tells us about the murder of Patrick Finucane, its circumstances, and the investigations that were conducted into it. It will allow us to take stock and identify those matters within the terms of reference, where the facts are now well established, and those that remain contentious and uncertain. It is intended as a starting point, identifying what can be agreed, albeit sometimes with caveats, and what requires further investigation. Such a hearing may also touch upon some procedural matters where early decisions are required. We hope that this hearing will take place in September. The publicly available material is incomplete and will not allow for a definitive history, nor would counsel to the inquiry seek to put a patent on such a narrative. Nonetheless, this work will serve several purposes. Most fundamentally, it will inform the public about some of the matters with which this inquiry is concerned. It will allow for core participants to consider and, where appropriate, to challenge that which is on the public record. In doing so, it will help to identify areas that require more attention than others in the remainder of the inquiry. It will help inform the issues that the inquiry will need to consider and the evidence that it will need to address them. Those are matters on which you will no doubt wish to hear future submissions from us and from the core participants. We feel that those submissions will be better informed once this review of publicly available material has been completed and presented. The terms of reference state that the inquiry must ensure that there is no unnecessary duplication of investigative work already undertaken. The approach we propose will be an important step in complying with that requirement. The second area of initial public hearings that is one that you have foreshadowed in your opening. We consider that an opportunity should be given to the Finucane family and others affected by events to speak about the impact of Patrick Finucane's murder. The murder was an act of abhorrent public violence with profound effects across society, but it was also a private tragedy. It is important that this is acknowledged and that those who wish to speak about the impact of the murder upon them are given the opportunity to be heard. Thereafter, we will need to develop a practical approach to the work of the inquiry, which allows evidence to be adduced, considered, and presented in a way that permits manageable hearings and informs public understanding. Much will depend on the nature of the evidence once inspected, but we see value in proceeding to hearings by reference to the various groups with which this inquiry is concerned. Those directly involved in the killing of Patrick Finucane, the roles played by the British Army, the RUC, and the Security Service, and the involvement of politicians and civil servants. This approach, by group rather than by issue, has several advantages. It is coherent for the public to follow. It allows for the efficient designation of core participants only to those sections of the inquiry with which they are concerned, which avoids unnecessary cost. It allows for core participants and counsel to the inquiry to make focused opening statements at the outset of each evidential section. There are also practical advantages to focusing each set of hearings on a particular cohort of documents. However, we stress that these are early days and that this is a proposal to which we will return once a more complete review of available evidence has taken place. We also note that there may be good reasons to take witnesses out of turn, for example, where age or infirmity means that their evidence should be heard sooner rather than later. We will invite you to take a pragmatic approach to such matters, but one always informed by the principles of fairness, thoroughness, and efficiency that I have highlighted this morning. That, sir, is all I say on behalf of the Council Inquiry team for now. We have a formidable task ahead of us. We will approach it with independence, with humility, and with determination. As you're aware, sir, a number of core participants have indicated that they wish to address you today with introductory remarks, beginning with the family. Before they do, may I invite you to rise for 30 minutes to allow the stenographers a short break. During this time, we would politely encourage those returning to the hearing room not to leave the site. Thank you, sir.
Thank you very much, Mr. Hill. The inquiry will now take a short break. I'll return at 12:10. 12:10. Thank you all very much. Thank you all. Please sit down. I'd now like to invite Mr. Danny Freedman, King's Counsel, to make his remarks on behalf of the Finucane family. Thank you, Mr. Freedman.
Thank you, sir, and thank you to yourself, your assessors, your secretariat and your legal team for arranging this first public hearing beginning of your work. Myself, Christopher Jacobs and Seamus McElroy are instructed by Martin Howe and David Enright of Howe & Co, and we act on behalf of the family of Patrick Finucane. All their lives will forever be affected by the murder of Patrick in the family home in front of Geraldine and the children on the 12th of February 1989. The Finucane family know they are not alone in Northern Ireland in having experienced this type of trauma, nor having had the truth about their loved one's murder withheld from them. But there are reasons that make Patrick Finucane's murder especially significant. Who he was, why and how he was killed, and the damage done by the state's continuing failure to account fully for what it did. In 1968, Patrick Finucane, the son of a man who had to work 2 jobs to feed his family, won a place to study English, French and philosophy at Trinity College, Dublin. He was the first in his family to go to university. By then, his father, Patrick Sr., and his mother, Kathleen, who had 8 children, lived in a rented house on Percy Street in West Belfast. This was not a political or a Republican family. Patrick's sister married an Englishman who served in the British Army. One brother moved to England and joined a religious order. Another married a lifelong pacifist. At Trinity, Patrick, a working-class Catholic from West Belfast, met Geraldine, a middle-class Protestant from East Belfast. However, conflict and politics engulfed this family, as they did so many others. They were politicised by events. In August 1969, hundreds of Catholic homes in Belfast and Derry were attacked. Patrick's parents and his younger brothers were forced out of theirs. The internment powers of 1975 were applied to the 2 of his brothers, one of them 20, the other just 16. In an age group where nearly 25% of the male population spent time in detention, the fact that some of the Finucane brothers went to prison was not unusual. By 1978, their father died in considerable part because of the stress that these events had upon them. Patrick Finucane did not join the IRA, nor was he ever unduly sympathetic to it, to quote Minister Douglas Hogg, speaking of a number of solicitors in the province in a debate on the Prevention of Terrorism Act weeks before the murder, having been briefed to say as much by the Chief Constable of the RUC. Detective Superintendent Alan Simpson told the inquest in 1990 that all police inquiries found was a law-abiding citizen going about his business. The coroner agreed, adding that the deceased was known inside and outside the legal profession to have discharged his duties with vigour and professionalism. The truth is that when bad things happen to this family, as they did to so many families in this place at that time, Patrick Finucane did not join a paramilitary group. What he did was to come home and to go to law school. And he found that he loved the law. He was not starry-eyed. He knew the pious platitudes about liberty and equality before the law were not applied equally in Northern Ireland, but the law offered a chance to help marginalised people who had no other constitutional avenue to help themselves. He and Peter Madden created their firm in 1979. Madden Finucane joined a small cohort of other lawyers, such as Oliver Kelly, who was Patrick's master during his apprenticeship, and P.J. McGrory, the lawyer who took the Gibraltar SAS shooting case to Strasbourg. Patrick's barrister of choice was Seamus Tracy, who became and is a Lord Justice of Appeal. Amongst many clients, including loyalists, Patrick represented Bobby Sands and other hunger strikers. For the family of Gervais McCurr, he challenged the incapacity of inquests to investigate the shoot-to-kill deaths. The Article 2 principles that lawyers so often cite today are the legacy of that case. To take the last year of Patrick Finucane's life. In January 1988, his affidavit on the ill treatment of Brian Gillen in the infamous Castlereagh Interrogation Centre led a court for the first time to halt policing interviews of a person detained under the Prevention of Terrorism Act by writ of habeas corpus. Later in the year, Patrick defended Patrick Maguire, whose charges for murder of two soldiers in Casement Park were dismissed by a judge holding there was no case to answer. In November, in the same week that the RUC were telling the government that Patrick Finucane was one of the lawyers, quote, in the pockets of terrorists, unquote, his client, Brian Pettigrew, was awarded exemplary damages by the new Lord Chief Justice Hutton for unrestrained revenge attacks by prison officers in the aftermath of the Mays prison escape. This is not legal history for its own sake. In one of the darkest times for the rule of law in modern UK history, Patrick Finucane and Peter Madden held a mirror to the establishment using the standards of the rule of law and of embryonic human rights. This defence of democracy would in time help open the path to the constitutional settlement Northern Ireland depends on to this day. But before then, it is the reason Patrick Finucane was murdered. To the crime itself. Those who organised and carried out the murder included British agents. They were employees, surrogates and assets of the Ministry of Defence and of the Special Branch of the RUC, or both. Brian Nelson profiled Patrick as the target. William Stobie supplied the guns. Ken Barrett was part of the assassination team. They were all members of the UDA, and Brian Nelson and Tommy Little sat within its chain of command. This murder was not an isolated incident. The relationship with paramilitaries that produced it was part of a widespread and systemic practice, one that successive governments allowed to exist with what Sir Desmond de Silva called, quote, a willful and abject failure to subject it to any legal framework, monitoring or serious censure. Documents now in the public domain show that for his legal work, the security forces regarded Patrick Finucane as a thorn in the side of the establishment. There were intelligence reports of threats to kill him in 1981, 1985, and November 1988, and each time, Special Branch decided not to warn him. Knowing he faced credible threats, MI5 deliberately spread false propaganda that Finucane was in the IRA because of the people he represented. Disgruntled army and police officials, amidst losing litigation that Madden Finucane brought against them, failed to stand Brian Nelson down or to disrupt the UDA's increasing fixation on this lawyer as a legitimate target in their minds. When the murder occurred, Sir Desmond de Silva described what followed as a relentless attempt to defeat the ends of justice. Information was withheld from the police. The army denied that it ran any informants in Northern Ireland. Evidence was hidden or destroyed. Suspects were tipped off before arrest. In 1990, just before Nelson was about to be arrested, Lord Stevens's incident room for his investigation burned down, and during Canadian Supreme Court Justice Corrie's inquiries in 2003, his computer hard drive was forcibly removed by MI5. Two features of these arrangements should never be overlooked, because together they meant, as Lord Stevens concluded, that the state had in effect sanctioned executions. First, men like Nelson and Barrett, who conspired to murder Patrick Finucane, were deliberately placed or left inside the UDA, not to prevent crime, but to carry it out. Second, from the 1970s right through to 1992, the UDA remained a lawful organisation, even though the police, the army, MI5 and the government all knew it to be a paramilitary body that was murdering people, knew its so-called military ring, the Ulster Freedom Fighters, to be a fiction, and knew that British state agents were doing the killing and being protected afterwards. The fact of the collusion is no longer disputed, but the journey to admission was torturous. And since then, the determination to control the truth rather than to ventilate it has been extraordinary. 2 decades after the murder, the government in 2011 accepted shocking levels of state collusion and issued an official apology. Then, instead of ordering a public inquiry, it appointed Sir Desmond as a private reviewer. Until the charge of government in 2024, this family were made to wait, even though De Silva recovered further wrongdoing, which has shown this murder and its cover-up to be more reprehensible still. It all begs the question, if the UK government has apologised, what is it apologising for? Accountability requires several things. Those responsible need to publicly account for their actions. There must be the fullest possible account of the facts. The survivors, never themselves accounted for at the time, must be allowed to give their own account and to challenge the accounts of those responsible. And accountability means learning, so that the state can be held to account in the future, so that things can change. None of this has yet been achieved. A private review, without power to compel a single witness or document, and without the family's involvement, could never fully interrogate the system in which this murder took place. The identity of all those who colluded and the precise nature of the help they gave before, during and after the crime have never been publicly disclosed. The extent to which the political, military and intelligence chains of command enabled the collusion under the governments of Margaret Thatcher and John Major and thereafter, and then became complicit in its concealment, have never properly been analysed. Even now, the barriers will work to frustrate this inquiry. The agencies concerned are practised in special pleading on delay, excused too readily by the sensitivities of the Troubles, and that plea will be made again, even though the files used by the previous reviews ought to be ready to produce at once. And then there is the question of truth itself. The right to the truth belongs not only to the bereaved family, but to other victims of similar crimes and to the public. Against that stands the recurring claim of national security. The family has heard the inquiry's anxious determination to disclose all information unless mandated not to do so by the law. On this, we know the family would want you to bear in mind the reality that does not appear in the law-reported cases. Too often, this family, like so many others, have been victimised by the misuse of the law on state secrecy. So when this family makes submissions against withholding evidence, they do not do so out of intransigence, but lived experience. State secrecy enabled the state's involvement in Patrick Finucane's murder and the impunity that followed. Truth is part of reparation and of recovery. Secrecy and closed proceedings are contrary to both. Sir, for nearly 4 decades now, our clients have fought one of the most powerful and tenacious single-family campaigns for justice that perhaps any of us will ever see. Yet they more than anyone understand that this inquiry bears significance beyond them. Patrick Finucane's death was a tragedy for his family, but it was catastrophic for the rule of law. The undoing of law and the traducing of democracy came not from below, from lawless and disaffected groups, but from above, from the state, its agencies and agents. The failure for so long to give the Finucane family or wider society of the truth is one of the reasons why Northern Ireland today may be largely post-violence, but it is not yet post-conflict. The inquiry has its role to play in helping that transition, to support the people of Northern Ireland to understand and reckon with their shared history, and to ensure that this family and all families bereaved by violence know the full truth about what happened to their loved ones and are granted the dignity and equality of justice that is due to them all. For present purposes, this is an inquiry into a state-sanctioned murder, indicating an utter failure of constitutional democracy in which the agencies established to protect its citizens and the rule of law murdered, facilitated murders, and obstructed and subverted the rule of law. Patrick Finucane's family, his wife, children, siblings, in-laws, and grandchildren are here today to say that it is high time that that truth was reckoned with. Thank you, sir.
Thank you, Mr. Friedman. I'd like to invite Martin O'Rourke, King's Counsel, to make any remarks he would like to make on behalf of Peter Madden.
My name is Martin O'Rourke. I am one of the counsel instructed on behalf of Mr. Peter Madden, who is a core participant in the inquiry. I appear with Miss Askin and Miss Smith, and I'm instructed by Fergal Shields of Madden and Finucane. We don't intend to make any introductory remarks at this juncture, but would like to reserve our position in that regard until a later stage of these proceedings. So thank you.
Certainly, Mr. O'Rourke. Thank you very much. I'd now like to invite Mr. Peter Cole, King's Counsel, to make remarks for the Secretary of State for Northern Ireland on behalf of His Majesty's Government.
Mr. Chairman, my name is Peter Cole. I'm instructed in this inquiry on behalf of the UK Government as a core participant in the inquiry, with my learned friends Mr. McGahey KC, Mr. Gray KC, Ms Ellison and Mr. McCartan. The UK Government in the immediate context includes the Northern Ireland Office, the Ministry of Defence, the Cabinet Office, the Home Office, the Foreign, Commonwealth and Development Office and the UK Intelligence Community. Each of these organisations has already engaged with the inquiry through the Government's legal team, and they welcome the opportunity to be represented here today, and indeed we have a number of senior officials here both in person and online to listen to what is said. This preliminary hearing marks a significant step in the progress of the inquiry, and my clients are committed to continuing the ongoing engagement to assist the inquiry in its important work. As the Secretary of State for Northern Ireland said when announcing the establishment of this inquiry to Parliament, Patrick Finucane was brutally murdered by the UDA on the 12th of February 1989. We further remember that Mrs. Finucane was herself shot and injured, and that this all occurred at the family home with the children present. It was a horrific crime. Since then, Mrs. Finucane and her family have worked tirelessly in search of answers about his murder. On behalf of the UK Government, it is acknowledged and recognised that this is a very significant day for the Finucane family. Mr. Chairman, everyone involved in this inquiry will be acutely aware of the number of previous investigations undertaken by the state over the years into this killing, including that undertaken by Sir Desmond de Silva QC. As envisaged in its terms of reference, the inquiry will be able to build on those significant investigative foundations and address the earlier deficiencies identified by the Supreme Court in compliance with the obligations under Article 2 of the ECHR. The UK Government looks forward to working constructively with the inquiry and the other core participants towards the fulfilment of the terms of reference. I made brief reference to the De Silva review. The inquiry will be aware that on publication of Sir Desmond's report in 2012, the then Prime Minister David Cameron spoke in the House of Commons of the, and I quote, frankly shocking levels of state collusion. He went on to say collusion should never ever happen. So on behalf of the government and the whole country, let me say again to the Finucane family, I am deeply sorry. The government reinforces the point made by the Secretary of State for Northern Ireland on the establishment of this inquiry when he said in the House of Commons as follows: "It is very hard for any of us to understand fully the trauma of those who have lost loved ones, sons and daughters, spouses and partners, fathers and mothers, and what they have been through. There is, of course, nothing that any of us can do to bring them back or to erase the deep pain that was caused. But what we can do is seek transparency to help provide answers to families and work together for a better future for Northern Ireland, which has made so much progress since these terrible events. I hope that this inquiry will finally provide the information that the Finucane family has sought for so long." Thank you, sir.
Thank you, Mr. Cole. I'd now like to invite Ms. Laura McMahon, King's Counsel, to make her remarks on behalf of the Police Service of Northern Ireland.
Chair, assessors to the inquiry and core participants, I would like to start by introducing the legal team assisting the PSNI at this inquiry. I am Laura McMahon KC, and with Mr Ian Skelt KC, we lead a team of junior counsel consisting of Joseph Kennedy, Helena Wilson, Christopher Wallace, Thomas Stewart, Rachel McGuckin and Richard Campbell, instructed by Richard Ferguson, Senior Legal Advisor in the PSNI. We are also assisted by dedicated PSNI personnel who will work with us to fulfil PSNI's obligations to the inquiry and the core participants. These opening remarks are made on behalf of the PSNI, and we're grateful to the inquiry for the opportunity to do so. Mr Finucane was murdered on the 12th of February 1989. The PSNI and its legal representatives for this inquiry offers its and our sincere condolences to his family. In 2012, following the De Silva report, the then Chief Constable offered an unconditional apology and accepted that the Finucane family had been abjectly failed. That serious issues arise from Mr Finucane's murder is very clear. Those have been touched on over the past many years through various processes, including the De Silva review and extensive litigation through the courts. Those issues form the background to this inquiry. This inquiry will examine the circumstances of the murder and will want to and will expect to make prompt progress towards answering the issues set out in the inquiry's terms of reference. The present Chief Constable has made clear that the PSNI will fully cooperate with this inquiry. The PSNI will provide to the inquiry all material relevant to the inquiry's work and engage constructively with the inquiry and the core participants. There has been much publicity about the strain on resourcing for policing generally, especially for the PSNI. It has to balance the work that it must do now, policing society in the present day, against its important obligations of dealing with our past. PSNI wishes to ensure the inquiry, the Finucane family, the core participants and the wider public that it has allocated significant resources to the inquiry and the work to be done to assist in its work. As the inquiry and participants will be aware, the PSNI holds much material, records and institutional knowledge that will be relevant to the inquiry's work. Experience in other inquiries has illustrated the challenges that are faced when dealing with materials relating to events that are now many years old. PSNI has already started a substantial information management programme to recover and structure historic records, many of which exist only in hard copy or legacy systems. The scale of the work is considerable, requiring the organisation and reconstruction of material from almost 4 decades ago across multiple investigations and systems. In addition to constructing systems for the organisation and handling of material, PSNI has put in place dedicated teams to handle both open and sensitive materials, supported by specialist researchers and the legal team. It is inevitable that at least some of the material and evidence that the inquiry shall have to consider will be sensitive. The PSNI has legal duties around the handling of sensitive information. Those duties are a matter of law and public record and apply in every case or inquiry. However, the PSNI repeats that it will engage constructively in this process and do all it can to assist the inquiry in its important work. In making these remarks about documents, we are not seeking to identify problems, but it is important that everyone understands the scale of the work. The work has to be done properly and comprehensively to ensure that this inquiry can achieve its goals and do so within a reasonable period of time. In summary, the inquiry can be assured that the PSNI has a clear understanding of its obligations and responsibilities and will take a positive and constructive approach to this inquiry, provide full cooperation, provide all relevant material and dedicate extensive resources to support the inquiry in its work. Once again, we thank you for the opportunity to be able to address you this morning.
Thank you, Ms McMahon. I'd finally like to invite Ms Claire Dobbin, King's Counsel, to make her remarks on behalf of Mr McElrath, Mr Simpson and Mr Brown.
Chair, I appear in this inquiry with Mr Sean Devine, instructed by Mr Winters and Mr O'Donnell, on behalf of Trevor McElrath, Alan Simpson and Johnston Brown. They wish me to reiterate on their behalf their condolences to Mr Finucane's family and his friends, and to acknowledge that it is only because of their resolve over decades that this inquiry is finally taking place. Mr McElrath, Mr Simpson and Mr Brown were RUC CID officers and part of investigations subsequent to Mr Finucane's murder. Each of these men has waited years in order to be able to give evidence in a forum equipped to get to the truth of how their investigations were frustrated and impeded by others, and what greater truth this reveals. They are grateful to you, sir, for having made them core participants and for the opportunity to play their part in getting to the truth. Thank you.
Thank you, Ms Dobbin. That concludes today's proceedings for the inquiry's first preliminary hearing. I'd like to thank all those who spoke for their contributions today and to everyone who followed the proceedings, both in person and online. I look forward to engaging further with you all as we move forward. I'm particularly grateful to Counsel to the Inquiry, Matthew Hill, for his helpful remarks in which he outlined a proposed way forward, including in relation to potential themes that might be explored in the next series of hearings. We hope to provide more details of those soon. As an inquiry will ensure that both core participants and the public are kept informed of developments and our intended approach. The inquiry will publish details of its progress and the next stages on the inquiry website in due course. Mr Hill referred to the enormity of the task ahead. We don't underestimate it, and we're realistic as to how long parts of it may take. Several council on behalf of both the inquiry and core participants, have referred to some of the challenges we face, and we don't underestimate them either. But everyone should rest assured that we will press forward with this inquiry with all of our efforts and with all possible speed. Thank you all very much.